Hello, good afternoon. I am about to start us off with the webinar for today. Thank you all for joining us. I will give about 1 to 2 minutes more so we can have folks join us for the event. And in the meantime, if you would like to share and introduce yourself in the chat and where you're joining us from today, please do so. We're glad that you're here. Great. Thank you, everyone. And thank you for those who are just joining us. Again, also feel free to introduce yourselves and let us know from where you are joining us from. Um, Welcome again. Thank you for joining. I'm Rachel Reyes, the Interim Communications Director here at the Center for Migration Studies of New York. I am surprisingly serving as the moderator for today as our Executive Director, Mario Russell, is resolving some tech issues. But let me also start with the title of today's program, which is The End of Birthright Citizenship. New study reveals significant damage to the U.S. economy. And we will all be discussing the new study authored by Philip Connor, Francesc Ortega, and Matthew Hall, and with also our guest, Smita Ghosh, to provide the background of the case that's now going to appear before the Supreme Court. This program is hosted by CMS, but also by Forward US. And before we begin, just so you know, this webinar is being recorded. I will post the recording to the event webpage on our website, cmsny.org. And if you have questions for our speakers, please submit them using the Q&A box in Zoom. We will reserve time at the end for discussion. And hopefully Mario will be able to join us as moderator at that point. In the meantime, I will serve as the introduction for you all. So again, welcome to today's panel presentation entitled The End of Birthright Citizenship. New study reveals significant damage to the U.S. economy. It's a pleasure to see so many of you here. Thank you for making the time to attend. By executive order issued in January 2025, President Trump mandated the prospective denial of citizenship to children born of parents present in the United States without status as of February 2025. That action was blocked nationally by several federal courts throughout the country and was not allowed to take effect until after review and a final ruling by the U.S. Supreme Court in a case called Trump versus Barbara, involving a Honduran asylum applicant mother due in October 2025 and filed in the summer of 2025. The Supreme Court is set to hear the case for argument next week, Wednesday, April 1st, to decide if Trump's order violates the U.S. Constitution's 14th Amendment guarantee of U.S. citizenship to any child born on U.S. soil. And we urge you to tune in to and listen to those arguments. This order, this birthright order, is one of many issued against migrants and refugees over the past 14 months by this administration, over 500 of them, which have created legal, social, and economic chaos, and more profoundly have triggered moral outrage and unrelenting, often violent, and frequently illegal actions around mass deportation. Detention, and arrest have now awakened in many an awareness that things have just gone too far, with wounds in our cities and communities that are deep and may be hard, if not impossible, to heal. Certainly, This is true for the 14 million migrants who are in um, liminal and undocumented status, many of whom have lived and worked here for over 10, 15, or more years, building the nation we treasure. But this birthright executive order strikes with a particular and malignant force at our American identity and traditions, both by revisiting this country's commitment to restore and advance equality and by reordering its foundational priorities and values. It also strikes its lifeblood in and resources, the work, talent, skill, education, and the gifts and genius the US born children of migrants have gifted and will gift the nation. So today, we are going to hear from speakers who will discuss the new research and findings from a study entitled Multi-Trillion Dollar and Multi-Million Worker Contributions: An Economic Accounting of Birthright Citizenship. This is published now in the Journal on Migration and Human Security, which is a publication of the Center for Migration Studies and is available on our website, cmsny.org. The study is included in an amicus brief filed with the Supreme Court by a group of concerned social scientists. We are deeply grateful for our speakers' time today, and especially for their work and commitment to facts, evidence, law, and history. You can read their biographies online, but I will introduce our speakers briefly here. Smita Ghosh is Senior Appellate Counsel at the Constitutional Accountability Center, and she will first provide an overview of the legal questions before the court and the historical framework of birthright. Then we will hear from the co-authors, Philip Connor, Research Fellow at Princeton University, and Francesc Ortega, Professor at Notre Dame's Keough School of Global Affairs. They will present on the number and characteristics of the persons affected by the order, their economic contributions over generations, and what will be lost if birthright citizenship is terminated. Because the numbers and implications are serious, $7.7 trillion contributed to the US economy, 3.1 million workers in the labor force, with $1 trillion in income, and at least 400,000 college-educated workers to be lost in the coming decades, significant and material consequences. There will be significant and material consequences. So let me now turn to Smita. Thank you.
Hi, everyone. Thank you so much for having me. I'm really excited to introduce this discussion of this great economic analysis by talking about the cases that have prompted it all, specifically the Supreme Court case that Rachel just mentioned, Trump versus Barbara. First, I'll talk a little bit about me. My name's Smita Ghosh. I'm a lawyer at the Constitutional Accountability Center. We're a nonprofit organization that aims to bring historical research into legal cases like this one in order to fulfill the progressive promise of the Constitution's text and history. And in this case, we filed an amicus brief on behalf of a group of constitutional law and immigration scholars about the history of the 14th Amendment. And it gestured to some of those historical American traditions that Rachel was just talking about. So I think talking about it will give a little bit of an introduction to both the oral arguments that you'll hear on Wednesday if you choose to tune in, and also just kind of the principles that are at issue in this case. So let's look at the next slide. This case concerns a constitutional provision and part of a federal statute. They both have the same text. They use this key phrase, subject to the jurisdiction thereof, but they're both from different parts of our history. So that kind of makes history baked into a bunch of different parts of this case. So the citizenship clause of the 14th Amendment of the Constitution says that all persons born or naturalized in the US are subject to the jurisdiction thereof. That's again the tricky phrase, I think, in this litigation, are citizens of the United States and of the state where they're living. So let's go to the next slide. I'll tell you a bit about the history of this clause. It's part of the 14th Amendment, again, which was added to the Constitution in 1868 after the Civil War. And looking at discussions of the members of Congress who drafted this particular part of the 14th Amendment, which I did do quite a bit of when preparing this brief, it becomes clear that this is a reaction to a Supreme Court case called Dred Scott versus Sanford. That was a type of lawsuit called a freedom suit, in which a man named Dred Scott, as well as his wife, actually brought suit to allege that he was being enslaved illegally. And that case made it to the Supreme Court. And one element of the majority's decision in that case, and an incredibly important part of the decision, kind of politically, in terms of its political ramifications, was the idea that the fact of the color of Dred Scott's skin, the fact that he was African American, meant that neither he nor anyone else uh, in that position could be a citizen of the United States, which meant that he couldn't even bring the case. The federal courts have jurisdiction over controversies between citizens of different states, and they said, well, he can't be a citizen, so he can't even bring this case in federal court. And that elicited tremendous controversy. It was seen by many people as incredibly damning in terms of the kind of racial makeup of the country. One of the justices who dissented in that case, who disagreed with that primary holding, actually left the court in protest. And the Dred Scott decision played a major role in kind of fomenting the sectional conflict that led to the Civil War. So after the Civil War and after the Reconstruction, Congress kind of assembled to remake the country. One of their first goals was to address this terrible decision, and they did that with the citizenship clause of the 14th Amendment. And I'll point out that they saw kind of traditional citizenship rules, which kind of had established this concept of citizenship by virtue of being born on the soil rather than who your parents were, as the tool with which to overrule Dred Scott. As one senator said, and I quoted him in this presentation, those rules generally held that every person, whatever your race or color, who was born within the United States was a citizen of the United States. But then decisions of the courts, and that's a pretty kind of explicit reference to Dred Scott, I think, had thrown doubt over the subject. So for that reason, the lawmakers who wrote the 14th Amendment really wanted to make it crystal clear that anyone born in the United States, no matter your race or color, was able to acquire US citizenship. So the point for one reason to highlight this, I think, is just when you're thinking about this debate, and if you are listening in on April 1st, the kind of existing law was something that the framers of the 14th Amendment referenced. So that makes cases that even came before 1868 kind of relevant, because the question is kind of what is that existing law? So but I can talk more about that in Q&A. So let's go to the next slide. And where I just wanted to point out that, again, the citizenship rule is in the 14th Amendment, but it's also codified by statute with the same language. The statute was originally written in the 1860s as well. It's been kind of like the language has been subtly changed in both 1940 and again in 1952. So one question the Supreme Court might engage with was kind of not only what did the phrase subject to the jurisdiction mean in the 1800s, but what did it mean in 1940 and what did it mean in 1952? So those are all these historical time points where if you're approaching these questions with kind of an originalist approach, which is what the most justices on the Supreme Court claim to do, these are the moments that you can really look at. So next slide. Again, what does this phrase subject to the jurisdiction thereof really mean? The people who are subject to this order, there's no debate that they're born within the United States, but what the executive order says is that we no longer consider them to be subject to the jurisdiction of the United States. And that's a real break from conventional wisdom about what this phrase means. Conventionally, it's been understood that being subject to the jurisdiction of the United States just refers to anyone who is subject to the country's power or authority. And how do we know that? From dictionaries, from the time that the 14th Amendment was written. How do they define jurisdiction? We also know that from a Supreme Court case called United States versus Wong Kim Ark, which was the first time the Supreme Court really trained its eye on this particular part of the 14th Amendment. The question in that case was whether an American-born son of Chinese immigrants should be considered a birthright citizen. He was born in the country, but his parents were immigrants, they weren't citizens. And the court there really equates being subject to the jurisdiction thereof um, to anyone who is owes obedience to the laws of the government. That's a phrase that the court uses there. So anyone who has to follow the law is subject to its jurisdiction. So that might make you wonder, like, what is the work of this? What does subject to the jurisdiction thereof really mean? Why is it? Is there anyone who's born in the U.S. that's not subject to its jurisdiction? So on the next slide, I explain. Let's go to the next slide. I explained kind of who the kind of narrow exceptions to this principle, who is born on the US soil but is not subject to the jurisdiction thereof. And you might see some of these groups appear in debates over on April 1st. So these might sound kind of arcane, but they did come up in again cases and debates about the 14th Amendment. These are the people who were kind of considered not subject to US jurisdiction all had unique roles in relation to the country's authority. So it's children of ambassadors and foreign ministers. Those are seen as people who had diplomatic immunities, so weren't necessarily liable to be prosecuted the same way that other people in the country were. Also, children who were born on foreign ships. Again, this sounds arcane, but in the law of nations at the time, if the ship is docked in the U.S., it's still not necessarily considered the same way as U.S. territory would be. It's sort of seen as a little bit of a separate jurisdiction. And then another thing that I'll point out, which might sound a little strange to people now, is children who are of members of Indian tribes, people who are born at the time the 14th Amendment was drafted. The framers made very clear that they didn't envision people who were born within tribal territory to become automatic US citizens at birth. And this isn't necessarily, the goal of this wasn't necessarily to deprive those people of something as worthwhile as US citizenship, as I at least initially thought, but also many argue that the framers of the amendment wanted to some extent, respect tribal sovereignty and not impose US citizenship on people who were really part of another nation first and foremost, but a nation that kind of had this unique colonial relationship with the United States. A lot of the framers say things like, well, we deal with native tribes with treaties. We see them as separate nations. We have an understanding that our laws don't apply in the exact same way there. So that's seen and recognized in this Supreme Court case, Wong Kim Ark, as another exception to this birthright citizenship rule. And that's kind of the work that the phrase subject to the jurisdiction thereof is doing. And I just want to point out, because I brought up this example of people who are born in tribal relations, that now Congress has written a statute that does provide birthright citizenship to Native Americans. So this is a outdated understanding of the Constitution that it doesn't reflect the state of the law now. So again, this is kind of the conventional wisdom of what does the 14th Amendment and the citizenship statute mean. Let me tell you a little bit about how the government argues its case, and I think this will dovetail nicely with how my co-panelists will kind of describe the people who are affected by the birthright citizenship order if it should go into effect. So let's go to the next slide. So the government argues that subject to the jurisdiction thereof means something different than government authority. They pose this theory of what they call political jurisdiction. And for them, that's a question of what I'm using phrases from the government's brief: permanent allegiance and a domicile. So domicile is kind of a term that comes up in a lot of legal cases that essentially means like, where are you? What's your primary home, your like fixed location? It's a question that often boils down to someone's intent. Do they live somewhere with an intent to remain there? The government says that domicile is sort of, despite not being in the text of the 14th Amendment, is this unspoken assumption within it. So only people who have domicile in the country are able to acquire birthright citizenship if they have children who are born there. And there's kind of two issues that I see with this argument that I'll just point out, two assumptions that are heavily contested here. One is that there is this domicile requirement in the 14th Amendment. And then second, the assumption is that people who are uh, children of undocumented immigrants or children of all the groups of temporarily present immigrants that are affected by the order lack a domicile. And again, as I explained, you might understand that like if the question is whether someone intends to remain, if it's someone's permanent home, that's certainly a category that could extend to uh, uh, children of undocumented immigrants or people who are quote unquote temporarily present. So that's an assumption that the government is making that's heavily contested in order to make this kind of idea of political jurisdiction apply to the people who are subject to the order. So that's kind of this new theory. It's made, I'll say, a lot by drawing a parallel between the people who are subject to this order and to those other exceptions like ambassadors and children of Native Americans. So that you can look out on April 1st if you're listening to the case for how Supreme Court justices understand this new theory. But for now, I'll leave it to my co-panelists to talk more about the economic impact of this theory if the Supreme Court agrees with it.
Thank you, Smita, for that wonderful introduction to the legal case. First and foremost, this is a legal case, but as a social scientist, I and other co-authors wanted to provide a sense of the economic outcomes and accounting of those that are benefiting from birthright citizenship in the past and currently and into the future. I am Philip Connor. I am Research Fellow at the Center for Migration and Development at Princeton University. Again, the title of the article that we have put together is Multi-Trillion-Dollar and Multi-Million Worker Contributions and Economic Accounting of Birthright Citizenship. It has been published just last week in the Journal on Migration and Human Security. My co-authors are Matthew Hall at Cornell and Francesca Ortega at Notre Dame. And I want to go next slide, please. Today, I want to be able to provide a bit of a background before we get into the actual heart of the results for this paper here. Again, when we think of birthright citizenship beneficiaries, ultimately, that is anyone right now that is born in the United States. However, we wanted to be able in this paper to more explicitly focus on a population that is particular to the executive order that the Trump administration released more than a year ago now. Those that are seeking to be children born in the United States to two undocumented or temporary immigrant parents as receiving birthright citizenship or not. As already is explained by Smita, there's legal precedence and practice that has been based on the 14th Amendment to grant birthright citizenship to these individuals of two undocumented or temporary immigrants. However, I wanted to be able to, again, to show some of the background here of the social science research that has demonstrated how children born in immigrant parent families have benefited greatly from U.S. citizenship, leading to mobility across generations. So, for example, we know that those that have been born to particularly two undocumented parents or temporary immigrants, some of them are now working in our military, they have started businesses, they have, through their citizenship, been able to erase some of the economic inequality that some of their families had experienced for generations, and also have alleviated geographic segregation because of their citizenship. Now, one of the great benefits of being a citizen through this lineage here is to be able to have access to post-secondary education. That has allowed many of these citizens to move beyond perhaps what they had experienced in previous generations in terms of access to education, and able to essentially have access also to licensing and credentialing, as well as job mobility. And families, we have been defined through the social science research, have been more likely to integrate in their communities when they have a U.S. citizen child. And certainly the child's academic performance has been supported by their parents when that child is a U.S. citizen. With all of this social science research that has looked at the importance and the positive nature of birthright citizenship on their future success, uh, we want to be able to look at more specifically what are the past, current, and future workforce and income contributions of birthright citizenship beneficiaries, particularly for those that were born to two undocumented or temporary immigrant parents. To our knowledge, this has not been done before, and in light of the executive order and the case of the Supreme Court, we feel this is an important piece of information to be able to have. Move to the next slide, please. Before we get too far into the economic outcomes, I want to be able to get a sense of the population that we're speaking of here. So when we are speaking of an undocumented or a temporary immigrant population, there is no central survey across the United States to identify those individuals. In fact, most often the survey that we go to be able to get a sense of the population that we're looking at here is the American Community Survey that is run each year by the U.S. Census Bureau. Conventional methods that have been used by Center for Migration Studies as well as other immigrant research population groups have relied on a conventional method to be able to identify through various means the undocumented or temporary immigrant statuses of individuals in this particular survey. And we went about doing that very same thing to be able to identify undocumented temporary immigrants in that survey. And because of that, we're able to identify rather readily the current beneficiary children born between 2010 and 2024, who are still living in their families' households if they were born to an undocumented temporary immigrant parent. And future children can be projected based on current couples that are undocumented or are temporary immigrants. So those are the two populations that we're able to do relatively easily. The more difficult one is to be able to look to the past and those that may have been born to an undocumented or temporary immigrant parent, two parents, I should say, as being a beneficiary of birthright citizenship. For that, we lean on the assignments that we have in the American Community Survey and actually extrapolate those into terms of probabilities for different birth cohorts into the current population survey. I know it's a lot of weeds, but the current population survey is a survey that's used typically for calculating unemployment rates month to month, again, run by the US Census Bureau. And there we're able to get a sense of the US born population based on information that's in that survey of the nationality of their parents. And we're able to apply these probabilities to be able to get a sense of the number of people that benefit from birthright citizenship since 1960 through as adults to 2009. And with that CPS information on current beneficiary adults, we can apply some occupational attainment and income to the past for those adults that are already in the workforce since 1975, and then be able to look at current and future children, taking that same information, looking at those same patterns, and applying those income and occupational distributions going forward to 2074. Now, these estimates are conservative. They represent past and future US born children of two undocumented temporary immigrant parents living in the US in 2024. And I want to emphasize that as living in the US in 2024. There are a number of groups here that could be missing that have benefited from birthright citizenship since 1960, which is the year that we kind of start this analysis. For instance, those that have left the United States, maybe moved back to their parents' home country, those that have since died and didn't are never in the workforce at all, or maybe only for a portion of their lives. It also does not include those that we can't identify clearly as to the nature of the immigration status of both their parents. For instance, single parents that might be in a home that are undocumented as a single parent, and they have a U.S. citizen child, but we don't know exactly the immigration status of the other parent because of the nature of those household formations. And so for those reasons, these are considered very conservative estimates. The reason we went about this kind of pathway was because we wanted a similar, consistent method and that we could apply to all people across all generations of these groups. So we have the conservative estimates, but they are to follow a very consistent method across the groups. Next slide, please. So some of the key findings that we find in this report, just so I can outline them, and they'll be unpacked here in the next few moments. Over the century period of 1975 to 2024, we identified 3.9 million people are birthright citizenship beneficiaries to two undocumented or temporary immigrant parents based on the criteria that I explained earlier. 3.1 million of those we would expect would be beneficiary workers that were added to the US workforce over that time period. And then 2.1 million of those are in occupations requiring some college education. $7.7 trillion of income or GDP would be added to the US economy over the century period by these millions of birthright citizenship beneficiaries. Now, what's most pertinent going into the future, especially given the executive order, as well as the case before the Supreme Court, We estimate in the next 2 decades that 750,000 of these beneficiaries would be in the workforce, of which 400,000 would be in occupations requiring some college education. And nearly 1 trillion alone in income or GDP contributions would be added to the US economy through just future children to be born in the next 2 decades. Next slide, please. And before we get into the outcomes, the economic outcomes more specifically, I want to get a sense of the population that we're looking at here one more time. So with nearly 4 million beneficiaries identified under this criteria, you can see how this breaks out differently across different states. So for current working age adults born 1960 to 2009, the top 3 states where they are living is in California, Illinois, and Texas. In fact, 2/3 of that total live in these 3 states alone. And that shows the migration patterns that many undocumented or temporary immigrant parents of these individuals took in the 60s, 70s, 80s, and 90s, and early 2000s. But that is quite different for current children born 2010 to 2024. Those individuals are, in terms of top states, are 3 again, California, Florida, and Texas this time. And in these 3 states, they only represent 1/3 of the total of current children born in those years that are benefiting from birthright citizenship. And that shows the more distributive nature, the nature of basically their undocumented temporary immigrant parents living throughout the United States and not concentrated in just a few states. Future children born 2025, 2024 also follow a similar kind of pattern of state residence. And then if we want to just take a few moments to be able to look at the totals for these different population groups, we identified 1.8 million current working age adults born 1968 to 2009 as birthright citizenship beneficiaries. Now, as I mentioned earlier, these are conservative estimates. So I do want to give you a sense of how much larger they could be based on different kind of assumptions within the data. So for example, if we were to identify in these current working age adults, parents that we only know the immigration status of a single parent, but not both parents, this number could go up as high as about 2.5 million. If we look at current children born 2010 to 2024, 1.3 million total is what our estimate is there. But again, if you look at individuals that we can't identify clearly both parents' immigration status, because we only know of one, that number could actually be as high as 3 million. And then if we look at future children born 2025 to 2024, at that 750,000 estimate that we have printed here, we can see essentially that if you were to include future immigrants, which is not included in our modeling, as well as those that are children today that are undocumented that might later couple with another undocumented individual and have children, we could see that population actually be as high as 4 million for those born in the next 2 decades. So when we're looking at this 4 million total, that total could be as high as 9 million or more. So when you look at these analyses that Professor Ortega will share for us in just a moment, I do want us to keep in mind that the estimates are conservative. They could be as high as double or more than what is shown here today based on using different assumptions within the data. And again, the reason that we chose to be able to go for the more conservative approach here is to basically provide a consistent method across all these 3 identifiable groups without kind of choosing in one direction or the other to add different assumptions. So with that, I'm going to pass it over to Francesc to be able to give some relay of some of the workforce and income contributions of this population. Francesc?
There we go. All right, thank you, Philip. All right, now that we've determined what is the size of the group of birthright citizenship beneficiaries, let's move and try to go on and quantify their economic contribution. Let's first think about their contribution to the labor market. Okay, it's what we refer to here as workforce contributions. There is an easy part, which is for current working age beneficiaries, we can just see in the data their labor market data. We can see if they're working, we can see their occupations. But for the children and for future beneficiaries, we don't have that data at this point. So that's the main challenge. How do we address that? Well, what we do is we're going to learn from the labor market experience of current working age beneficiaries, and then we're going to extrapolate to the children. Let me be a bit more specific about how we implement that strategy. In the 2024 data, we see who's working, we see their occupations, and therefore it's easy to classify all these workers into two broad occupational categories. One of them we call high-level occupations, and those are occupations typically requiring some college education. And the rest of occupations are inside another group that we call low-level occupations. We create this occupational classification separately by age group and by state of residence. Just to give you a sense, the top 5 high-level occupations in today's labor market are office personnel, sales managers, healthcare professionals, general managers, and teachers. Of course, over the next few decades, the labor market is going to change. For instance, the demand and the size of specific occupations may be affected by new technologies and whatnot. However, we think that the high and low broad occupations, this will still remain relevant. Okay, now before I show you our estimates, so I want to highlight the underlying assumption that we're making here. What we're assuming is that the children or the unborn beneficiaries of birthright citizenship will reach the same broad occupational distribution as the current working age beneficiaries. Next slide, please. Well, I've already talked about which are these main occupations, so let's move on to the next slide, please. Okay. All right, so at the bottom, if you look at the totals here, so this table is, so the total all the way to the right is saying that out of the 3.9 million beneficiaries, about 3.1 will become workers, and through their work and their earnings contribute to the economy. The two columns in the middle classify these workers in the two broad occupational categories. So we see in the first of these columns that the occupations typically requiring some college, those are the high-level occupations. The US total for that is about 2.1 million workers, so roughly 1/3 of the total contribution to the workforce. These numbers actually vary by state, largely reflecting the different size of the group of beneficiaries across states. Okay. Just to pick out two numbers, so the two states for which birthright citizens provide the largest contribution in terms of workers are California. By the end of the century that we're analyzing, California will have added 559,000 skilled workers, and Texas over 400,000. Next slide, please. We want to take our analysis of the economic contributions one step further. Okay, we've already looked at the labor market, how many workers are coming out of the group of beneficiaries. Now we want to quantify that in terms of their contribution to GDP, okay, their income contributions. To estimate these contributions, we again are going to rely on the labor market data of current working age beneficiaries and then extrapolate to children. Specifically, we're going to look at the 2024 current population survey data, and we are going to compute the average income that includes both earnings and capital income for working age beneficiaries. We do this separately by age group and by state of residence. So for each state, These data provide an idea of the income age profile, describing how the average income earned by workers in the state evolves over time as their professional careers, as they move along their professional careers. As expected, the profiles, you can see in the paper the actual data, but the profiles have the expected shape. So as people gain more experience and progress in their careers, their average earnings go up, they peak at some point, and then at the latest stage of their career, average income falls a little bit. Okay, so this inverted U shape is the usual shape that labor economists have shown for age income profiles. These age income profiles that we have estimated for each state are very useful because they allow us to calculate the average lifetime income earned by each cohort in each state of residence. Okay? So specifically, with this data, we can project income. So for workers that we see only in 2024 in our data, we can use these profiles to project income backwards to age 16, the beginning of their working life, and also to project their income forward all the way to retirement, adding up the income earned by workers throughout their lifetime. That's what we call lifetime income. Notice that once we have these age income profiles for each state, we can also apply them to current children. Of course, we don't know yet. They haven't started working. They haven't started earning a salary, but we can make projections using these age income profiles. The underlying assumption is that the occupational attainment of these kids will remain broadly similar to that of the previous cohorts. Next slide, please. When we apply this methodology to our data, then we were able to quantify this contribution. So the table you're seeing here, if we go all the way to the right and all the way to the bottom, we see that once you add up the income earned by all beneficiaries over the 100 years that we're studying, the total contribution to the economy is $7,693 billion. That is nearly 7.7 trillion. That's the contribution over this period to GDP. These contributions vary by state, and again, they mainly reflect the differences across states in the size of the beneficiary group. In California alone, the income generated by birthright citizenship beneficiaries is above $2.2 trillion. And in Texas is also is above it's nearly $1.3 trillion. Now, to just get a more intuitive sense of how much money we're talking about here, so if we divide the total contribution, the $7.7 trillion, by the 3.9 million beneficiaries, we get that in per capita terms, the average beneficiary will have generated about $2 million in income over their lifetime. The second column from the left zooms into the future beneficiaries of birthright citizenship. And all the way to the bottom, we see that we are projecting forward. We predict that if birthright citizenship stays, this group is going to generate $927 billion over their lifetimes. Okay, so nearly $1 trillion. Next slide, please. So I know this has been a lot of numbers, but so here our main conclusion, or what we've done in this study, is we have presented baseline estimates of the economic contributions of birthright citizenship beneficiaries to the US economy. Our estimates are conservative. For instance, as Philip explained, we are not counting here contributions from individuals that were here, contributed to the economy, but have since died or emigrated. Those individuals we do not see in the 2024 data, therefore we're not counting their contributions. We're also not counting contributions that would be made in the next few years by new arrivals. Therefore, our numbers can be considered as a lower bound. I would also like to mention that our methods and our findings can provide the basis for future analysis by us or by others. For instance, they could be used to provide detailed estimates of the fiscal contribution that birthright citizenship beneficiaries have had to the US economy. They could also be used to estimate how the economic contribution of these beneficiaries would be diminished if the executive order stands. Okay. So what we provide here are estimates, assuming that birthright citizenship keeps going. But of course, if it didn't, then the economic contribution of future beneficiaries who would not benefit, who would remain undocumented, would be much lower. And that's an interesting and important calculation that one could do starting from the numbers that we provide here. With the numbers that we have shown here, we can already get an idea that those impacts would be significant. Okay? They would easily imply a loss of hundreds of thousands of skilled workers and hundreds of billions in lost income. And thank you very much.
Thank you to all of our speakers, to Smita, Philip, and Francesc. Let me stop sharing the screen. We do have questions for our speakers, and I just want to encourage for the rest of you who haven't yet been able to submit a question, feel free to in the Q&A box in our Zoom meeting. So some of these questions I can start us off with. And first, I would ask Philip, actually. This question is directed to you. Why the century timeframe? It seems like a fairly large duration of time to measure the contributions of those who would be impacted by the SCOTUS case.
That's a great question. Thanks, Rachel. So we want to be able to get a sense of lifetime contributions and not just in any one given year or just one given decade. As you can well imagine, anyone that is employed in the workforce, they have their education years, then they have also follow through in terms of their early careers, their mid careers, their later careers, their occupation changes over that time period, perhaps. Also, we can see that their income would change over that time period. So we wanted to be able to have kind of a sense of their lifetime contributions. And in order to do that, for these three groups, it demanded for us to actually have this kind of century-long period. I realize it is a long period of time, but it was by which we could actually identify those that actually came in since 1960, that were actually born since 1960, and then forward to 2044 to get that sense of that century time frame. So it's to get that lifetime, that things can change over one's lifetime, to be able to get their total contributions to the country given their citizenship status.
Thanks, Philip. And in regards to Francesc, if you take into account educational investments by local, state, and federal governments, is there still a net contribution to the economy by birthright citizenship beneficiaries?
Yeah, great question, Rachel. So our estimates, when we think about the economic contribution in a per capita sense, imply that the average beneficiary of birthright citizenship over his or her lifetime contributes close to $2 million. Now, it's interesting. So your question is about how does that compare to the educational investments that local government, the local, state, and federal governments have made in contributing to educate those individuals until they become productive workers. And estimates of those investments range in the $250,000 to $310,000. That's the overall government spending in educating these students all the way through high school, and taking into account that some of them go on to college. So those $260,000, $300,000 are just a fraction of the $2 million that over their lifetimes these workers contribute.
Thank you, Francesc. And this question is for Smita, as well as there's a few more questions for you as well that you and I discussed if you wanted to respond to those. But starting us off with this one, can you tell us more about the Wong Kim R case? I know you really briefly touched on it, and why it doesn't or does or doesn't resolve the issue here. Me.
Sure, I'll be really quick about that because I know lots of people have questions. That case was about a the child of Chinese immigrants in the 1890s. So I think the debate on that case um, is the government's argument that that type of person isn't really parallel to the type of person who's affected by the order, because there wasn't a concept at the time of being a temporarily present immigrant or an undocumented immigrant. So they're saying, oh, that case was dependent on the fact that Wong Kim Ark's parents were sort of like a legal permanent resident today, even though that category didn't really exist. So it's kind of like, can you confine it to those facts, or is the case a much more sweeping kind of endorsement of this definition of subject to the jurisdiction thereof? And then I also saw a question in the chat about like what types of temporarily present groups the order applies to. And I wanted to direct people's attention to this order put out by USCIS, US Citizenship and Information Services, about the that gives a little more detail as to like which categories of people would qualify as temporarily present versus not. And I did notice that I think someone had mentioned asylees, and another person in the chat mentioned tribes that travel between the US and Canada. And those groups I think are understood in this implementation document as like not temporary enough to qualify for under this order. But then there's a lot of groups that would be qualified. And this is just how the government says right now that this will be implemented. So like, depending on how the court rules, I'm sure a much more broad what the government's advocating for is a more broad exception to birthright citizenship. But if the implementation document's helpful, I'll send it around. I can post it in the chat.
And this question is for Francesc. Wondering how we counter a potential economic argument from the government that by restricting access to education for children of immigrants, there will be less benefit to the children of immigrants, or will there be less benefit to the children of immigrants? Their stance would be counter to socioeconomic policy, of course, but is one that the administration seems to be pursuing. I don't know if you have any comment on that.
Yeah, so definitely there's tons of evidence in labor economics that education increases workers' productivity and income. So obviously any actions that would lead to lower educational attainment for any group of children could definitely have negative consequences on their future labor market opportunities and on the contribution that they would have to the US economy.
And kind of as a follow-up, because this concerns the study. So does the study, and this is for both you, Francesc, and Philip, does the study take into account inflation? And what about increased social inequality?
Great question, because I should have mentioned that earlier. So all the figures here when it comes to our income contributions that we have calculated, as well as GDP, which is essentially the contributions to GDP, are in 2024 dollars. And correct me if I'm wrong, Francesca here. So essentially, we're talking about it in today's dollars, looking to the past, and then also looking to the future. So that's 7.7 trillion in 2024 dollars of that time frame. In terms of what could occur in terms of future social inequality, we didn't model of how that might alter in the years ahead in any way. And certainly, there would be differences in inequality in the past than what there is today as well. But we just want to kind of give this kind of mid-century view of the greater century that we're estimating here. Francesca, if you have anything to add there, happy to hear some more, but I think that may cover it.
I I can add a little bit. So
Okay.
I think it's important to view our study as what it is, no more, no less than what it is. So it's a descriptive analysis. It's really just an accounting exercise of what has been the contribution of this group. Okay? It's an elaborate accounting exercise. It requires a lot of demographic work so that we can determine what is the right size of the group of beneficiaries, but it just describes with some assumptions what is happening. Okay. Then there can be questions about counterfactuals of what would happen if the legislation changed and how would the economy respond if then there are changes to education, access to education, or changes to the labor market. Well, the economy would be affected, and there would be perhaps some sort of adjustment. Like that's beyond the scope of this study. We have not covered that here. We've just described what has happened, is happening right now, and will happen in the foreseeable future.
Thank you. We have another question regarding the study or knowledge of any other study. So has there been any study to compare the economic impact of workers who are and or remain citizens with workers who would stay in the US and continue to work as non-citizens?
So that is simply what Francesca was kind of mentioning earlier. So it's kind of describing a situation where you have a counterfactual situation where if the executive order were to stand and you and the Supreme Court decide to agree with the government on this order, and we had a population that were undocumented, that were born in the United States for years going forward, what would be their kind of lower level of income or workplace contributions under that scenario? That is one that we did not estimate here. It is simply an accounting exercise to be able to get a sense of if they were to have birthright citizenship, what would be their contributions that in a similar concept patterns of what we've seen already for the previous 50 years. And so we don't articulate that, but certainly, as Francesca mentioned at the end of his presentation, this is an area of research that could continue to go forward. We kind of provide the baseline estimates to provide that next step of the research if it were to occur.
Thank you. And thank you all. We are almost at time at the 2 o'clock hour. There's one last question about whether we've heard from the Trump administration, if any acknowledgement of the insights that have been produced, if anyone has any insight. But I will remind everyone that the study has been cited in an amicus brief that was submitted by concerned social scientists. So it at least has made it to the Supreme Court. All right. Thank you all again for joining us. On behalf of Mario Russell, who is the executive director for the Center for Migration Studies, he sends his apologies for not being able to join due to technical difficulties, but has been watching the presentations and we've all been very pleased with your participation and interest in the report, in our presentations. Just a reminder, the webinar recording and slide deck will be posted to our website, cmsny.org, under the events tab. And we do have 2 forthcoming webinars, one which will be with More in Common on communications, and one that's not yet scheduled, but will be on the 2024 estimates of the undocumented. But this is the first time our analysis will be incorporating temporary and liminal status, people with temporary and liminal status. So please keep an eye out for that. And if you're not already on our mailing list, please subscribe. Thank you all again so much. Thank you to our speakers, to Francesc, Smita, Philip. Thank you very much. And I will close today's webinar. Have a good day. Bye, everyone.
Bye-bye.